Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be discussing documentation for Canadian investors and with a specific emphasis on E-2 visa holders as well. E-2 option that many Canadian nationals utilize as a first step to come and establish a longer kind of permanent level. This is a little table of contents overview of what we're going to cover today. We'll talk a little bit about EB-5AN. We'll introduce our guest panelist, Carolyn Lee. We'll talk about how does the E-2 visa fit in with EB-5? What are the key similarities and differences? We'll talk in a lot of detail about source of funds considerations for Canadian investors. As a reminder, source of funds is the required component of an EB-5 petition where you have to document that your funds, investment funds, have been legally earned and taxed before you can be approved for the green card. We'll spend a few minutes talking about a real case study about an EB-5 investor from Canada who's making an EB-5 investment and what documents this person needs. And then we'll chat for a few minutes about current urban and rural TEA projects as well at the very end.
Sounds great.
A little bit about EB-5AN. We're a national EB-5 regional center and investment fund manager. We've worked with thousands of investors over the last 10 years. Our regional centers cover the entire United States, so we can do projects anywhere in the US, which gives us great flexibility in terms of identifying the lowest risk investment opportunities for our global clientele. We've worked with investors from more than 60 different countries. This is a map showing where many of those investors have come from over the years. Another map showing all of our regional centers that cover the entire country. And as I mentioned earlier at the beginning, I'm Sam Silverman, one of the two managing partners of EB-5AN. My partner Mike on the right side there. A little bit about our bios below. And as you can see, we're from kind of the institutional investment in the EB-5 space for over 10 years now. And without further ado, it's my great pleasure to introduce Carolyn Lee. Carolyn's an expert EB-5 immigration attorney. She's been in this space for a very long time, and I'll let her jump in and share a little bit about her experience in the EB-5 space as an attorney, and also her work with many Canadian E2 and EB-5 clients over the years.
Oh my goodness. Well, Sam, thank you so much for that very kind introduction. It is my pleasure and honor to be with you. EB-5AN has an exceptional reputation. I think you've really done incredible work in this space, and I do believe this is my debut with you, so it's a very special honor indeed. I won't go too much into my experience, but just by way of introduction and a hello, I have been very privileged to have been very active in this space, and what that's really allowed is afford sort of a panoramic view of the program's evolution and its growth. And it's very fitting that we're talking about Canadians today, because Canadians were among my very first EB-5 clients and my very first E2 clients as well. And for reasons that I hope we'll explore today, we'll talk about why the investment immigration options, including E2 and EB-5, make so much sense. That they work really well for many Canadians, but also we want to be careful. There are established lanes, which is so nice, but we want to stay well within those lanes to craft a successful case. So I'm really looking forward to our discussion today with Sam.
Perfect. Thank you very much. So as kind of an overview, before we dive into the details about source of funds, documents, and really the nitty-gritty, let's first start with kind of a general overview of how E2 works. What is E2? How does it work? And then how does that kind of fit in with an investor who's considering EB-5, who may already be on E2 or might do E2 first, or maybe they don't do E2 and they just decide to go straight from being a Canadian citizen to an EB-5 investor.
Yeah, I love this slide, and your team has done a really wonderful job beautifying the ideas. So I see this decision tree, if you will, the consideration for a Canadian investor who's currently in Canada, deciding which route to go. Should I go directly to the EB-5 and how does that map out? Versus should I go the E2 route and how does that relate to a potential EB-5 down the road? I kind of view where that investor is in terms of timing and certitude. There are some investors for whom they know, they have certainty, I just want the EB-5. And it's for all sorts of reasons. They want to establish residency and maybe as soon as possible for a variety of reasons. Maybe they have children aging out and they don't want to mess around. They know they want to pursue an EB-5. Well, in that case, we have this route displayed on the bottom here in blue. Then there are other investors, and they also, who are considering various options before them, and they can be entrepreneurial. They may have desires and ambitions to maybe develop a business or a branch business in the United States, or to do more with an existing commercial presence in the United States, or they may just need a little more time to think about whether EB-5 is really the best fit for them. And so they kind of need staging ground. And for those investors, the E2 can be the appropriate way to go because the E2 kind of allows them to establish a firmer foothold or a foothold commercial presence in the United States. And it also allows them to kind of ease into and build toward their plans, firming up their plans for permanent residency. So it is what I call sort of certitude and timing decision tree right here for the client who's outside the United States. And Sam, I can kind of walk through the two different processes.
Yeah, I think maybe before we go step by step, maybe just talk a little bit about just what is an E2 visa and how do you get it and how does that kind of differ from what you get with an EB-5 investment?
Awesome. Yes. So they are related, the E2 and the EB-5, in that they're both premised on investment into an enterprise in the United States. However, they're quite different in terms of their substantive requirements. Well, for one thing, the EB-5 investment visa is a permanent residency visa. It's a green card. It's about your permanent establishing lawful permanent residence in the United States. The E2 is a temporary visa, even though it's renewable indefinitely. It doesn't have a cap like the H, for example. But it is a temporary visa that does require the intent to depart after completion of the E2 assignment in the United States. And there is then the investment amount threshold issue, which is also quite a big distinction. With EB-5, there is a set investment minimum threshold by statute, and it's $800,000 if the investment is in a TEA, as most of EB-5AN's investments are. If not all. With the E2, we don't have a set limit, or rather a threshold of minimum investment. There's more a rule of thumb, which we might get into a little bit. The figure $100,000 is commonly sort of discussed, even though we don't have a statutory minimum, because there are other requirements that the investment be substantial in relation to the type of business we're talking about, and that the concern has to be real and operating. And so we do have to establish that this business is a real business and it's bona fide, and the investor is putting in enough to ensure its eventual success, for it to create enough income for the business not to be marginal eventually within, as short a window as possible. And by marginal, we mean a business that's yielding enough revenue for the investor and the family to live in the United States. So it's a rule of thumb, that 100K number, but it's not a requirement.
Got it. Okay, great. I guess maybe let's first walk through the E2 process and then talk about EB-5 separately.
Sounds good. Okay, so you'll see that I put there, the first step is a consular application. And that is a unique feature of the E-2 visa, as opposed to many other kinds of visa categories on the non-immigrant side or the temporary side that start with a USCIS petition. So if you're a Canadian doctor or a nurse, or you may have started your work visa application process with a petition, even if that petition is submitted initially at the border. With the E2 is a unique visa classification in that the consulate, the US Department of State, has unique authority and jurisdiction. So you can actually apply for the E2 via a petition filing in the United States. You can file for a change of status. For example, you may enter as a visitor. You may decide that it makes much more sense for me to stay in the US on an E2 basis, and then a change of status filing absolutely can be made and successfully adjudicated, giving you initially a 2-year stay. But eventually all roads lead to consular processing in Toronto for an E2 visa, because eventually you'll want to leave, go back to Canada or elsewhere, and come back. And to do that, you're going to need to apply for an E2 visa. And when you do, the consulates, because of their special authority, will have de novo or fresh review of your E2 visa application. So it's not, okay, so USCIS adjudicated you're E2 worthy and we're gonna just, literally stamp your visa. No, it's a fresh adjudication, so that application is made anew at the consulate. So usually the process begins with a consular application in Toronto. And that process, it varies. The timing has been varied, particularly post-COVID. The consulates around the world, these some years post-COVID, are still recovering from the effects of the pandemic, where they've lost staff and capacity. So the timing of the visa interview process in Toronto has been a bit erratic, but I will report that because the process is set up to self-help, clients have been very successful, even though they've been scheduled for an interview 12 months after application. Enterprising clients have been able to get in there in the portal and grab a cancellation and be scheduled for a visa in about a month, as early as a month from the time of the submission. So there is that, that give there as well in terms of getting an interview after the application is made. So then you actually have a face-to-face interview with the consulate in Toronto. And if all goes well, you'll be approved for the visa, and the visa will be issued usually by post. They come, you submit your passport and it'll come to you by post. That visa is going to be valid for 5 years. Now, this is new for Canadians, for many, many Canadians, because Canadians are visa exempt. It's like not even visa waivered, you're visa exempt. So when you come into the United States, you don't need a visa to come in as a visitor. So again, this is a special process. You're applying for an E-2 visa. You'll get a 5-year visa when approved. And you present that visa when you come in next at the port of entry.
Got it. Okay, that makes sense. All right, I think that's good for this slide. Now let's let's dig in. I think maybe just as a final point is that the E-2 visa gives investors the ability to come to the US and work with a fairly low minimum investment. I know we talked about $100,000 as kind of the minimum. So with $100,000, you can come to the US, open up a business. Let's say it's a lemonade stand. You're open, you can stay in the US with you and your family. And as long as that lemonade stand is open, you're going to continue to avail yourselves of that work permit, permission to be employed and remain legally in the US. But the second you close down, you decide you want to stop working, retire, whatever, then that's it. You run out of runway, you've got to go back to Canada, and there's no path to a permanent, retired, visa-free
Yeah.
life.
Or you're at an earlier stage in life and you have kids, and we have these clients, happily Canadian E2, wonderful business, but their oldest kid is turning 21. And so that is the time to pivot the thinking about an EB-5 investment.
Yep, exactly. Yeah, there's a number of different factors and benefits that'll apply, depending on what stage of life and if you're looking to retire or set up the next generation. So yeah, those are all items to consider.
Yeah.
Okay, so let's talk a little bit more about E2. So we know it's minimum. What else needs to happen to make sure you don't get denied for an E2?
Yeah, this is good. And when in thinking about this presentation, I was thinking of a particular Canadian client who went through very successfully and just, oh, this is easy, I'm going to tell all my friends. And the answer is that it was easy because she had an awesome business that met all the requirements, that was beautifully prepared. So if there, you can have a business that's beautifully, that's a real business, it's wonderful. And by that, we don't mean that it's necessarily out of the gate making gobs and gobs, because you do have that runway, and everyone understands. The consulates in Toronto are going to understand that, especially for startups that are just starting operations or on the cusp of being operational, that you're going to need that little bit of time until you get your revenues up. And so that's where the business plan, which is another important element of all of this, can come in to really kind of tell that story. I really think that, so it is about meeting the requirements, of course, and your, good advisors are going to guide you through those, the investor, through those requirements. I really think that the cases that tend to do well are the ones that can really tell that story. And the story is both on the business side and on the investor side. And one of the advantages to Canadian investors is that that story is very accessible. It's like palpable, because there's a familiarity and a kinship, if you will, with the documents and with your with the systems. So like a property deed is going to be very, very recognizable to us and to the adjudicator, and the transactions that are often involved are going to be very familiar. There's not a stretch of imagination to kind of picture, what happened there. So I think that the successful stories, the successful cases, are the ones where you can really tell that story about the business, about the applicant, about the investor, and the source of funds. And it does tend to be, it's easier with Canadians.
Got it. Okay, that makes sense. All right, now let's dig into the source of funds. So I guess first, what is source of funds, and why is it so important, and how does it fit in the context of an EB-5 application? What is the government kind of, from a policy perspective first, at a high level, what are they trying to get at here, and how do we kind of navigate the rules to make sure an application gets approved?
Yes, this is super important. And I'm reminded humbly that these are benefits, and that there really are important policy objectives that the examiners, whether it's a consular officer or USCIS examiner, they need to feel comfortable that they are allowing an individual a benefit that they're due. And one of the most important requirements for that benefit is that their source of funds for the investment come from lawful sources. So we cannot use capital that is not from lawful sources. In fact, it is defined as not capital. It's that fundamental. If it's not lawful, then it's not even capital. And so it's very, very important. One has to take it very, very seriously from the investor side and also from the advisor side. That's just sort of the premise of it all. That said, if they are indeed lawful, which in 100%, I would say, of our clients, it is, then it's about documentation and the robustness of the documentation and the flow, the story. We call it the narrative, the source of funds narrative. And again, this is where that idea of telling the story comes in. I'll just say one more thing before Sam asks his next question. We're not going to have a checklist. We don't have pages of regulations or guidance that says this is okay, this is okay, this is not okay, this is not okay. So it is about judgment, I'll say, but it's nothing very, very specialized or technical. I would also say it's about your common sense. It's as you work with a client, and we're working on the strategy and keeping in mind that narrative and what evidence is available, it's quite natural to imagine oneself in the examiner's shoes and going, okay, so that's your story. All right, so what do you have to show that? What do you have to show this? And you just sort of imagine the questions a sensible person, any sensible person, not necessarily one that's technically trained, any sensible person might have. If you want to establish a point, what would you show? Okay, if that's available, wonderful. If that's not available, what's the next best thing? So there's a lot of common sense involved, which is affirming.
Yep, exactly. Yeah, overall, the government wants to make sure that the money that's being invested has been legally earned, and that the investor who's getting the benefit can show where that money came from. That's really what it comes down to. And there's no one size fits all. Everything is very, very custom. There are some best practices for sure, depending on the type and category of income that you're going to show, or inheritance, gifts, all of that, which we're going to cover in more detail. But high level, as long as you can document how the money was obtained legally, meaning taxes were paid in most cases, then you're going to be okay. So I think let's now shift over to just the 4 food groups, the most common sources. Mm-hmm. And Carolyn, do you want to give us kind of an overview of these 4, and also talk a little bit generally about what's common for an investor? Is it typically all from 1 bucket, 2 buckets, all 4 buckets? What do you see in real life from many clients over the years?
Yeah, great question. Although I must say, this doesn't have chocolate, so it doesn't have all the essential food groups. These are great buckets. These are the most common buckets, right? And I would say off the bat, before kind of drilling down into each, in most instances, it traces up to somebody's income, somebody's earned income. And we see a lot of gift cases. So it's not going to be the donee, the investor whose earned income is at play. It's going to be whoever the donor was and his or her income. So in most instances, you're tracing up to somebody's earned income. Now, there are also cases that are not uncommon where you trace that person up and it goes back 100 years. And you know, we'll talk about that because those are very interesting. But eventually, you know, so ordinary income, to your question, Sam, that's the most common. And we're talking about, you know, funds earned by somebody up the chain. And it's usually by employment earnings. So we're, you know, again, the story, who was the employer, how was it earned, how much, over what time. Capital gains, yes, as well. So with those earnings, somebody has bought an asset or assets, whether it's securities or real property, any kind of property. And that property that asset has grown in value over time, and you're capitalizing on that value growth, and you liquidate it and you use those proceeds. So again, in those instances, we're tracing up to, well, how were those assets initially acquired? So again, we're kind of looking to income, earned income. Gifts or inheritance, when there is a gift or an inheritance, we're looking to the donor or the decedent. You know, again, the source of the funds. So we're kind of piercing through the investor to the ultimate source and asking the question, well, where did that person get the funds? So it's the same analysis, just sort of once removed.
So you basically just can't say, oh, my friend gave me a loan, he gave me a gift, and then leave it at that. That's not going to be sufficient.
Correct, right. We have to ask, well, how did he or she get it?
Yep, exactly. Okay.
Yeah.
Perfect. All right, let's dive. I know there's a lot to cover. We'll spend more time on each one individually and really dig into.
Cool.
So ordinary income first. What do you see? This is probably the largest, most common source. So what's important for ordinary income?
Yeah, and so, you know, again, common sense kind of stuff. So it's going to be it's often accumulated income over time to the point of the gift or the investment, or it's accumulated income to the relevant point, the asset acquisition or the purchase time. So we're time traveling, we're going back in time. And we're asking, okay, so what was the source? Who were the employer or often employers? In the EB-5 context, we've got to go back 20 years of employment, even if earned income is not relevant to the source. So, you know, we're going back in time anyway. And for earned income presentation, we definitely have to trace it up to the relevant point in time and the relevant sources. So it's often employers, who they are. I love it when we can point to who they are. So, you know, the examiner doesn't have to go, is this really real? Who are they? Often there are public sources, a website, URL that we can point to, that we can look and we can pull down information from even. And so we want to establish who the employer or employers were, that they actually existed, that they were bona fide. And then what is the relevant person's position in that organization? How long did they hold the position? How much did they earn? And all the proof of it. Canadians, you know, we have T1s. We're going to have T1s. And often the records are, you know, unless we have to go back to, you know, 2000, which sometimes we do, you're going to have those tax records. So yeah, it's pretty straightforward.
Got it. Can you talk a little bit about the tracing aspect of it as well? How does that fit in, and what's going to be needed for that?
So important, because this I think is a point that is, you know, kind of worth fleshing out, because clients, investors think, okay, yeah, I gotcha, you know, source of funds, it's, you know, I sold this, I earned that. But it really, this tracing part is important for both the E-2 and the EB-5. It isn't enough to say, okay, so we've traced it. We've traced the, whatever it is, the 200K or the 800 plus K. We've got to go, all right, so then these are the steps that those sourced funds took before landing in the U.S. enterprise, whether it's the new commercial enterprise in the EB-5 context or the E-2 enterprise in the E-2 context that meets the nationality requirements. So it's like it is like sort of like a it's literally a path of the funds that we're tracing, usually through bank statements.
Okay, perfect. What's a capital gain, and what are some of the most common kind of situations that you see with capital gains?
Yeah, so capital gains is sort of it's a financial term. So as immigration lawyer, we're very careful to say we're not advising you on tax or anything related to finances or financial investments or suitability. But the idea in terms of the source of funds is that you've bought an asset, and by you I mean the investor or the donor or the testator or whoever this ultimate source is. They have bought an asset at some point in time. And again, we're going to be tracing, where the funds came from to buy that asset in the first place. That asset, not always, by the way, right? Sometimes there's a loss, but that's okay because there was enough initially. So often that asset will have grown in value over time. With real property, it's easy because we have the purchase price and then we have the sales price if it's a sale, or if it's a mortgage, we have an appraisal that backs up the mortgage loan. So, but with securities, it is more document intensive because you'll be able to show time one when those securities were acquired, but you've got time two when those securities were liquidated. And so it's you do have to think about and talk about what the best evidence is to explain and to trace the growth in those securities, the growth in value in those securities. Often it's going to be in the form of statements, which many clients have fastidious records of. So it's usually not a problem. It's more of a document management kind of an issue, especially if it's securities that have grown in value over time.
All right, great. Tracing obviously applies for capital gains. All right, another really common source that we see are gifts and inheritance. So let's talk about both of those and cover kind of the few most important items that come up for those.
Sure, yeah. So when we have inheritances, we, again, just sort of thinking this through from a very sort of logical, common-sensey perspective is very helpful. Okay, so who is the decedent? Who is the decedent to the investor? Usually there's a family relationship. So what's the family relationship? And the documents to establish the family relationship. So, if it's a parent, long form Canadian birth certificate. It's going to establish the parent-child relationship. If it's a grandparent or somebody whose name does not appear on the birth certificate, then we're going to have to trace those steps up. So we have the long form that shows the parents, and then we've got to have the parent's birth certificate that shows the parents' parents. That's going to establish, in that example, the grandparent to the child, to the investor relationship. We're going to have to show the existence of the instrument, the will, and what was the disposition of it was, how it was, the probate process. Sometimes statements from the advisors involved, the attorneys involved, are appropriate where there's privacy issues or, if it's like voluminous records. But you want to establish the relationship, the asset, the amount, the entitlement. Very similar kind of logic in the gift side. Who is the donor? What's the donor to the investor? Answering the question why, and then tracing the assets as we talked about earlier.
Okay, perfect. And the final one is loans. So
Yeah,
and this is a little more complicated than the others. So yeah, tell us kind of what you're seeing with respect to loans.
Yeah, so the interesting thing here is the availability of personal loans, particularly personal loans that are unsecured. This was disfavored, but in the EB-5 context, under the new law, the EB-5 Reform and Integrity Act, it is specifically permitted. And also, the law is memorializing a federal court decision that specifically reversed the service who said no to these kinds of sources of funds initially. So it is for sure okay, and they don't have to be secured. So a personal loan is going to be a loan, a promise to repay, usually on the part of the investor, right? To the lender, whoever it is, a family member it can be, and the loan proceeds, the loan amount is going to be 800 plus the admin fee, and it is going to be used for the specific purpose of making an investment. Now, it does not have to be secured, which means that it does not have to be backed with collateral. If it is, though, if it is a secured loan, then the collateral must be collateral that is owned by the investor. It's probably irrelevant for this discussion, but we do have a body of law that the service does sometimes confuse in interpretation, and it's with this concept of indebtedness capital, where if the investor is contributing not cash to the new commercial enterprise, but that note, indebtedness, like an IOU, rather than investing $800,000 in cash, I'm going to say, I'll pay you, at some point in the future. In that case, you can't use the new commercial enterprise's assets as collateral for that IOU. And you sort of have to do a time dance into the 90s to imagine what they were talking about, because it's like the new commercial enterprise is your own company, is the investor's own company. And so there can be, just a little bit of confusion, like a confluence, a conflation of the assets of the company and the investor. And so this decision says, no, you cannot use, even though you may think that your company's assets are yours, sort of, you can't use those assets as security for your own loan to your own new commercial enterprise. Talking about it like that, I can see how many people might be confused, but that's usually not a scenario that's in play today. Almost all of the instances are going to be contributions of cash for your new commercial enterprise. So we took a long side road there about collateral. Source of funds of the lender, exactly the same as our discussion about the gift and about the will, the inheritance. We go to the lender. How did the lender get the EB-5 funds or the funds for the loan? Same analysis. Did I talk too much, Sam?
No, that's good. And again, same tracing is going to apply, although probably a bit simpler for a loan situation. All right, so now we're gonna get a little bit more complicated and walk through a real case study that combines a number of these prior topics that we discussed in the context of an investor who's getting a loan from a friend and then is making an EB-5 investment. So maybe let's first kind of start just numerically, just 1, 2, 3, and kind of go through the whole picture and what documents and records are going to be needed for each piece of the puzzle.
Cool, let's do it. All right. So number one, you got to show who the investor is, right? Yeah. So passport, birth certificate, Yes, if there's a driver's license, all of that good stuff. And for the dependents as well, particularly for filing a concurrent adjustment of status application. Prove it's a real asset. Great. We do, if it is a loan that is secured by real property, as in this case, what we want to show is that this asset, this collateral, has a value that supports the loan value. So we want to get a valuation of that asset, and it's got to be third party, you know. So if it's real property, it's easy. Get a real estate appraisal that shows the market value of that real property. Number 3, source of funds used to purchase the asset. We talked about this. So we want to show when was the property acquired, with what funds. Okay. Number 4, prove it's a market transaction. Yeah. So, you know, it's a friend, it's your parent. However, we do want to establish 100% that this is a bona fide transaction. It is a bona fide binding transaction. And so the documentation really has to reflect that. So I advise that we get a lawyer to draft the loan documentation as if it were an arm's length transaction, and to have the terms run as such. And now let's look at the friend who is loaning the funds to the Canadian investor. So it's a U.S. national, and they own 100% of a digital consulting business. And so, you know, we're sourcing the lender's source of funds for that 800 plus loan. So the business, you know, does it exist? So formation documents, what's the ownership? So, because we have to establish that the friend has the authority to make this loan based on his or her interest in the company. So the ownership of the company. And then the company can distribute its income in a number of ways. It can literally distribute its income in the form of dividends or distributions, or the friend might be taking a salary from the company, or both. So we want to get a handle on how the funds from the company are flowing to the friend and from the friend to the company. And then let's see here, number 6. Right, so we do want to establish the identity of the lender. And this is also important as a sort of a side note, to the extent sometimes these transactions are from the source that's not the investor. So for example, in this case, the friend might be authorized to fund the loan proceeds directly to the new commercial enterprise. You have to paper all of that. And particularly if that's the case, we have to have the identity in the record of the whoever is transferring the funds to the new commercial enterprise on the petitioner's behalf. So yeah, we definitely want to establish the identity of the lender here, and the passport birth documentation and driver's license is going to do that. And now here we are at number 7, proof funds were legally acquired. Right, exactly. So kind of, you know, same analysis. What does the company do? How did it make its funds? So we're going to have the company tax returns, right? We're going to have, you know, 1120s possibly up at the entity level, and we're going to have 1040s at the individual friends level to establish earnings at the company level and earnings at the personal level of the friend. And we also want to establish, you know, again, how those funds came down to the friend. And we'll have some corporate documents usually to establish that. We'll have corporate resolutions, for example, authorizing the dividends or distribution or something similar.
Got it. Okay, perfect. And just as a quick overview, this is an example of a cover letter, which is kind of the summary that is provided by an immigration attorney to USCIS, which lays out all of these different documents, exhibits, so that everything's all organized in one particular spot. And here's just kind of an example of, you know, what those documents look like. And as you can see, there's quite a few of them. It's not just 2 or 3 things. There's going to be a lot of bank statements. If there's a loan we've got death certificate, will. So the source of funding is going to define what types of documents are going to be needed. It's important to work with an experienced EB-5 attorney who's seen hundreds of situations and knows exactly what documents are going to be needed and which ones are not going to be needed as well. Carolyn, I'm sure you have some thoughts on documents and the letters. So yeah.
Oh yes. Oh yes. We at our firm have many regular conversations and meetings about about the presentation, because we got the facts, all right, and how best to present that narrative in a way that flows. We really talk about that a lot in our office, and the ordering of the document, the language, the presentation of the exhibits, the organization is a very important part of it. A very important part of it, and it's worthy of constant, re-engineering and thinking. And every case is different, and kind of, respecting that as well. So yeah, this is a critical part of it.
Now we'll shift gears. Thank you, Carolyn. We'll shift gears and chat for just a few minutes about some of our current $800,000 rural and urban TEA projects, and then we'll wrap it up with some more thoughts on Canadian source of funds. So as we discussed earlier, there's two types of EB-5 projects currently, primarily rural and urban projects, or high unemployment is the same thing. So on the rural side, most of our investors under the new RIA rules that went into effect in March of 2022, investors who select rural projects benefit from priority I-5 260 processing, so they get approved faster. And there's a greater number of visas set aside. 20% of the total 10,000 visas each year are set aside for investors in rural projects. So you get through the application process faster, and there's more visas available. And those two factors combined results in it taking less time from start to finish for you to obtain a green card in your hand. So that's why rural has tended to be a bit more popular and more beneficial for those investors. On the rural side, we have 3 different rural projects open for investment today. Our Twin Lakes, Georgia project, the first one, it's a large multi-family or single-family home community located outside of Atlanta, 1,300 homes total. Over 600 homes already sold. The project's already profitable. It's been so popular in EB-5. We've done 2 prior funds, both with exemplar approval, and one with I-5 260s already approved as well. The developer, Coulter, is one of the largest developers in the US. They were just listed as one of the top 20 national private home builders in the whole United States. They've done almost 200 projects. They've never failed to repay a loan or to complete a project ever. And we've done more than 15 prior EB-5 projects with them with 100% approval rate. And their parent holding company is providing a repayment EB-5 loan. So very low risk project, lots of jobs already created. Is probably our most popular rural project. We also have our Kindred Keystone project, which is a large condominium and hotel project that's being managed by Vail Resorts, public company, and the hotel to the primary ski gondola at the Keystone Vail Resort, which is the 4th most popular ski resort in the entire United States. So A+ location, already under construction, 70% sold, and all the jobs already created with a first priority mortgage. And lastly, our Walhalla, Utah project, Another single-family home project with amenities just north of Park City, Utah. Phase 1 almost sold out, over 500 jobs already created, and has the 956F approval and many 526C approvals as well, with secured first and second mortgages. And then shifting down to urban TEA, this is the same project, our Boynton Beach multifamily, but we have two different offerings, equity and debt. And on the equity side, a 5% preferred return for investors, and on the loan side, a 3+1 year loan term. Also being developed by Coulter, amazing location. Construction is starting in the next couple of months. Land's already secured, and is going to be a great project. Also targeting 55-year and up active adult market as well. So a number of different projects. Our goal is to kind of have a one single portfolio of projects. Some investors are going to place a higher value on a higher return and a shorter investment period. Others want to focus more on capital safety and a faster green card. And so we've got a portfolio of different options based on what the personal and financial goals are of an investor. And this will also the investor is born in will also kind of play a factor in how long it's going to take to get through the green card process. If you have any questions or want to get more details about any of these projects, please reach out to us, and we're happy to share more details about any of them. And before we wrap up, Carolyn, maybe can you give us kind of a quick overview of, today is February. I'm losing track of the days here.
It's the
February 28th, 2024. So maybe tell us a little bit about, what's happening in the market today, and, with the up partial investments, what's kind of happening right now in the market that you're seeing, and that, you can kind of advise investors to take into account as they're exploring EB-5, at the end of February.
Yes. So we're the fees for EB-5 benefit applications and petitions are going up substantially April 1. So and for projects, they're going up by $30,000, and in the EB-5 investor petition side, they're going up by about $7,000, and the filing fees will be over $11,000 from being about $3,700 today. So as a result, we are anticipating a heightened demand that will have to be managed in the coming month of March, which we're labeling here March Madness. I think that yes, it is for folks who want to capture that window and make sure that their cases are postmarked before April 1. You want to try to act as quickly as possible. And the nice thing about Canadian, since we are talking about Canadian investors today, is that the documents can be quite straightforward. Not always, but they can be. And we don't have the very burdensome currency transfer processes that we have to manage in other jurisdictions, and very, very carefully. So I would say it's a window that's possible for capture, particularly if you've started the process even before then. That said, no reason for rushing. The most important thing is to craft the best possible case under the circumstances. And so getting good advice on that front, it's more important to get it right than to do it quickly. And I think being aligned with good folks, good partners on the side of the investors is very important in that respect.
All right, perfect. And also maybe spend 1 minute and talk about just the partial investments and what that looks like for someone considering doing a filing before April 1, and how that would be beneficial for them.
Sure. My office tends to be a bit conservative on this, of course, and I don't think we're alone. If the investment can all be stacked and filed with, completed investment with your 526E petition, that's of course the ideal. But particularly when one is managing deadlines, whether it's a filing deadline, filing fee deadline, or an age out deadline, these are real deadlines. Sometimes you just can't get every tranche over the hurdle. And in those instances, yes, the law does permit investors to be in the process of investing. So this is, yes, an avenue that is available, and one just wants to be careful about crafting the investment and the documentation to give assurance to the adjudicator that yes, indeed, we're in the process of investment to be completed, ideally within a defined period of time that is presented in the initial case.
Excellent. All right, perfect. Thank you very much, Carolyn, for taking the time to join us on today's webinar. We really appreciate it, and yeah, we'll get this out. And thank you again. We appreciate it.
I am grateful to you. Thank you so much, and it was fun. And thank you for the great questions.